All right, well, if we can start to find some seats, we're going to get started here with day 2 here in a few minutes. If we can just find seats. Well, good morning. I'm Joel Krautter, and I will be introducing Montana Supreme Court Chief Justice Mike McGrath here momentarily. But before I do, on behalf of the members of the Constitutional Convention Celebration Committee, I want to welcome you to day 2 of this special celebration of Montana's 50th anniversary of our 1972 Montana Constitution. Just a few housekeeping items. We want to remind everyone to silence your cell phones as we get started here today. And for educators and lawyers seeking credit for today's sessions, we do have sign-in sheets in the back room near the registration table. Given all the work and planning that has gone on ahead of the event, as we get started here today, I want to acknowledge my fellow members of the Constitutional Convention Celebration Committee. Our 2 co-chairs were both Con delegates, and they're both retired attorneys. Maynan Ellingson of Missoula and Jerry Lindorf of Helena. Con historian Evan Barrett of Butte. Former Montana State Legislator and Indian Education Specialist Norma Bixby of Lame Deer. Former Montana Senate President and Secretary of State Bob Brown of Whitefish. Former Montana Attorney General Tim Fox of Helena. Attorney and former State Senator Mike Halligan of Missoula. President of the League of Women Voters of Montana, Nancy Leifer of Missoula. Executive Director of Leadership Montana, Chantel Schiefer of Helena. And Rob Saldine with the University of Montana's Mansfield Center and Political Science Department. So like yesterday, today we again have a packed agenda of some great panels lined up for all of you. And Maynan Ellingson has again tasked myself and Rob Saldine with keeping everything on track today and on schedule. So, it's now my honor to introduce Chief Justice Mike McGrath. Chief Justice Mike McGrath was raised in Butte, Montana. He has served in the U.S. Air Force and is a graduate of the University of Montana and Gonzaga University School of Law. Over the course of his legal career, he has served as a Reginald Heber Smith Community Lawyer Fellow, Assistant Attorney General in Montana, Lewis and Clark County Attorney for 5 terms, 2 terms as Montana's Attorney General, and he was first elected to the Montana Supreme Court as Chief Justice in November of 2008. Let's give a warm welcome this morning to Chief Justice Mike McGrath.
Good morning. I look around this room and I see a lot of distinguished folks here, a lot of people that I have admired for years. Unfortunately, years being the operative term. Some of us have been around quite a long time, 50 years to be exact. But it's great to see that you're all here. It's wonderful that we have the opportunity to come together at a time to celebrate what was accomplished 50 years ago. Recently I saw on public television, I think it was, they had a montage of graduation speakers and sort of cut the messages about what speakers had said across the country, and of course, you know the lines. It was, "You're the future of this country. Everything's open to you. You all have the opportunity to really make a difference. You have the opportunity to change things. It's up to you with dedication. Work hard, play by the rules, those sort of things, those optimistic comments. But as a practical matter, most of us don't really have the opportunity to really make a change and do things different. That, of course, was different in Montana 50 years ago. The people that gathered in this room for those 2 months made an incredible impact on a change of direction in this state, and a document was created that will serve the people of this state for another 50, probably 200 years to go. They did make an incredible difference in putting this document together. It was a controversial time then. It was a controversial time now. The changes they did adopt. By the way, I don't know if you saw Governor Schwinden's piece in the Independent or in the Lee papers yesterday, but it did a very good job of sort of relating the history of what was going on in Montana before the CON came together. And it was, if you haven't seen it, it's well worth taking a look at. Can't read my notes, huh? As I said, it was a controversial period of time. The document only passed by 2,500 votes. It was a squeaker. It was a close call. But my contention would be that the support of the public has grown. And over these past 50 years, not only has the Constitution been accepted by the people of Montana, but I think it's admired by the people of Montana, and I think it enjoys a great deal of public support. It's a document that was adopted for the benefit of the people. You know, the federal Constitution, the Federal Bill of Rights, for example, is a limitation on government. It's phrased more or less in negative terms. Thou shalt not, you cannot. Montana, we have a different situation. We have a Declaration of Rights, well over 30 of those, that provide rights specifically to the people of Montana. You have the right, you have the ability. It's a different tune. It's a different approach, different tone, rather. By the way, I've for almost 50 years now been perusing this document, had the opportunity to use it actually for the last 13, an opportunity to interpret it. And one of the things that I appreciate the most about it is how well organized it is, how well written it is. It's you know, there was, as many of you know, there was a committee on style and drafting. I mean, it was important to the delegates at the time that this be a document that was internally consistent, that was easy to understand, it was easy to read, easy to comprehend. And in my view, that's one of the reasons that the Constitution has enjoyed strong popular support. People can understand it, people can read it, it's easily accessible, it's discussed a lot. And personally, from my point of view, I am confident that this Constitution enjoys strong support. I would contend that if it was put to a vote today on a yay or nay, we'd be much, much further ahead with the yays than the 2,500 votes that it got those 50 years ago. I think it enjoys strong support, and I am very confident of that and the fact that the people will support this. So for those of you who were here, thank you and congratulations. For those of you who are here because of strong support for the Constitution, thank you. Keep up the good work. Thanks for being here. Thanks for having me. Have a good day.
Good morning, everyone. I am Lisa Skari, daughter of Carmen Skari. I'm going to share with you the invocation he wrote and shared March 14th, 1972, which was on the 45th day of the convening. In talking with my sister Tala about this, and she was also a page during the ConCon, she remembers Dad laboring over this and wanting to write something that had meaning and that spoke to everyone that was gathered. So here are his words. As we begin a new day, may we continue to feel the sense of importance of what we do. May we be aware of the limitations of our knowledge and the existence of our prejudices. May we be tempered by this self-knowledge, but not intimidated from making the decisions that we must. May we have confidence in our ability and a proper respect for the opinions of our fellow delegates. May we not forget that we represent not only those who have sent us, but for those who are not yet born. For this purpose, we ask for guidance, for knowledge, for wisdom, but most of all, for tolerance and understanding. Amen.
We're just going to get our next panel ready here for a few minutes.
Okay, good morning. It's nice to see some familiar faces in a different context than I used to see them in. Our first panel this morning is going to be on the rule of law, which is the foundation of our system of government. And I think that the rule of law has some different meanings to different people, so I tried to come up with what I hope is a fairly generic definition of the rule of law, and that is that everyone is accountable to laws that are publicly adopted, made known to the public, and that are equally enforced. And the rule of law is designed to be a limit on the arbitrary exercise of power. And it means that that exercise of power is always subordinate to well-defined and established laws. Now, even though this panel is about the rule of law, I think we're going to delve into a lot of the separation of powers, which is how the rule of law is basically created. Now, because my experience and my career was with the legislative branch of government, I was more familiar with the unruly law. Before every legislative session throughout my career, I read two things before every legislative session. The first thing I read was the Montana Constitution. And it really doesn't take very long, but it's amazing what you find contained in the Constitution, and sometimes you forget what is contained in the Constitution. And the other thing I read religiously was Lewis Carroll. And that prepared me for the legislature. And I found great wisdom in the words of Lewis Carroll, so I'm going to start our discussion on separation of powers with an excerpt from Through the Looking Glass. When I use a word, said Humpty Dumpty in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master, that's all. Our panel is going to appear in the order that the branch they're representing appears in the Constitution. And it also makes great logical sense because this is how the rule of law plays out in reality. So our first speaker is going to be Representative Bill Mercer, who is a member of the House of Representatives from Billings. And Representative Mercer is also a former U.S. attorney, so he has a broad experience with the law. And he's going to talk about the inherent authority of the legislature and the Constitutional Convention's attempts to strengthen the legislative branch, which was always probably the weakest of the branches of government under the 1889 Constitution. And part of that was because of the abhorrent history of the legislative branch under corporate dominion for many, many years. So, Representative Mercer.
Thank you, Greg, and good morning. I come to you as a 58-year-old who, as an 8-year-old, got to be in this chamber because my father was a legislator. And so I see former legislators out there with whom he served and who, through my eyes as an 8-year-old page, I learned an awful lot. And I think that if, unfortunately, we don't have enough people that get to be in this building when they're 10, 11, and 12, I think we might have more people inspired to serve in those chairs. So he ran the last time there were county-wide elections. He ran for re-election the first time there were single-member districts. And obviously he served in the only session in which there were annual sessions. So that was my context in my youth, and it framed my interest in public service, and no doubt is why I'm a legislator today. As Greg said, I'm going to talk about 4 things today. I'm going to open with what Maynard Ellingson has framed as the goal of the delegates to, quote, fully make the legislature a strong and equal third branch of government. Then I'm going to talk about the attempts of the convention to enhance transparency. I'll do a very quick drive-by on what I think happened with education policy and the challenges that that presents for us in the current environment, and 4, rulemaking and the tension between the executive branch and the legislative branch with rulemaking authority. So back to what Delegate Ellingson has framed in her writing as the goal, what the delegates encountered based upon the 1889 Constitution. Well, Article 5, Section 5 said no session shall exceed 60 days. And by the time the delegates convened here, there were a number of facts that suggested that that was problematic. The legislature rarely completed its business in 60 days. There was actually a tradition of quote-unquote stopping the clock that allowed, I think you could argue, ultra vires activity after 60 days that probably in the modern era would be challenged. But at any rate, it was clear that the work was difficult to complete in 60 days. There were only 100 bills approximately introduced, I believe, in that 1971 session. To give you an idea how that's changed in the modern era, we had 1,120 bills introduced in the 2 chambers in 2021. That may be excessive, but clearly given the scope of state government, it would be very difficult for us to do the work in 60 days, and I think that was a great advance in terms of the Constitution. Another factoid, back in 1970, the state budget was $380 million. We appropriated in the 2021 session $5.3 billion for the biennium. So the work, the venture is much more complicated, and I think the idea of annual sessions of 60 days each would be far preferable to what we have. And of course, that was the mechanism that the convention put into place. It was immediately eroded by the voters, and we haven't had annual sessions since 1975. Another thing that obviously has to be mentioned in this context is I don't think that those who were delegates could have anticipated that in the early 90s, the voters would have adopted term limits. And that obviously has a significant impact in terms of the work of this body. To give you a little context of the 100 chairs that we have in front of, I have in front of me, in the 2021 session, 35 of the people that sat in those chairs were first-term legislators. That is a dramatic difference from what Representative Bradley and Representative Tao encountered when they were freshman legislators in the early 70s. Some might say that there was too much institutional interest, that you had people that were in this chamber for a long, long time. On the other hand, it allowed something like a person like Francis Bardenow to serve here. And I think he's recognized by many people as a very significant, the most significant legislator. But that was because he knew the appropriations process, because he had the historical knowledge. And we are deprived of that today. So term limits couldn't have been envisioned, but I think when you talk about that challenge of is this a strong and equal third branch of government, I don't think there's any question that term limits undercut that. There's a lot for a citizen legislator to learn. I am not enough of a scholar of the Constitutional Convention to know if there were any members who said we should have a full-time legislature. I rather doubt that. I doubt people wanted to have any large number of people serving as legislators for their employment. So this structure in many ways has its strength in that we all leave here and go back and do real work in our communities. We aren't full-time employees, but it is also a challenge. So what are we doing to try to strengthen the branch that I think you can argue has been undercut by those developments? We obviously, unlike the other branches, we don't come to work every day. We come to work for 90 days at the beginning of odd-numbered years, and then we try to work in the interim. We are trying, I think, to figure out ways to strengthen the branch. And if you take a look back from 1973 to the present, you see a lot more emphasis in terms of the work of interim committees. So we may not be here every day, but we continue to be here. I was here all day yesterday for a full-day budget committee meeting. I'm here all day today for the Legislative Finance Committee. So we are busy in that capacity trying to make sure that we are on top of the way things that we funded are being implemented and the way things that we need to monitor, like where are we on revenue, where are we in terms of the expenditures that we appropriated, we do try to monitor that very carefully. But I'd be kidding you if I told you that that was anything like being here every day and trying to be fully engaged. Secondly, I would say a really important thing that continues to expand in capacity is the professional staff of the legislature. So you've got 150 elected officials, but you have a tremendously strong group of scholarly folks that draft all the legislation. So occasionally someone will call me and say, why don't you have your staff write a letter or draft a bill? Or, well, I don't have staff. The legislature as a whole has very excellent staff, and they draft all the bills, and they're the ones doing the revenue estimates, and they're the ones monitoring what the expenditures are in the executive branch. So we have a lot of capacity in legislative services, the legislative fiscal division, and importantly, the legislative audit division, which is not really like the federal model of inspectors general because the auditor isn't embedded within an agency, but they do program reviews and they do audits for the legislative branch, and that capacity is crucial. So those three entities, we couldn't do the work without the professional staff that we have. Oversight, which is certainly related to what I was talking about in the interim, but I like to say we're the opposite of Congress. I think Congress really at this point, the sclerosis of Congress precludes it from really legislating effectively, but man, can they execute oversight. They are tremendous at show hearings and doing all sorts of things to try to take a deep dive into whatever is happening in government, outside of government. We are really good at legislating. As I said, we had 1,120 bills introduced. 589 of those reached the governor's desk, of which he vetoed 17, and we overrode one veto. So we can legislate like no one's business, but on oversight, we're not so good. And that's the place where when you have many thousands of state employees executing the mission of state government, but a legislative branch trying to decide what should our appropriation policy be, what is it that is being effectively implemented or not, what programs are essential or not. That's an area where we are not terribly strong, and we are trying to develop additional capacity. So that's subject one. Subject two, transparency. I guess I would be more charitable here. I think the context with which the delegates were faced, you had no recorded votes on second reading. And second reading is the time when in both these chambers, that's when the debate occurs. That's the first time when people take a vote outside of committee. Those weren't recorded votes. Committee sessions were held, executive work sessions were held sometimes not in the open. So neither the press nor the public had any sense of what was happening within those executive sessions, and votes weren't recorded in those committees. So the right to know in general and all of the rights of public participation effectively opened up all legislative proceedings. So now in the modern era, you can watch every committee hearing, including the executive work sessions, on public streaming. You can check every recorded vote that happens either on this floor or in committee. There is total transparency in terms of what actions, who takes what action, what amendments are offered, what speeches are given. And so that's a significant change, and I think in keeping with the goal of saying we need more transparency, and that's going to lead to accountability and an effective record. And I don't think there can be an argument that we aren't the most transparent branch. You don't have a chance to watch court proceedings. You don't get a chance to watch justices deliberate in terms of what they're thinking in terms of the various arguments. And within the executive branch, there are all kinds of things that are happening within every 5-minute increment, and you don't have any optics into that whatsoever. And the right to know bridges that to some extent, but again, you may be able to serve a right to know request in an executive branch agency and get certain documents, but I think you would be surprised at what you're not going to get in terms of emails what you're not going to get in terms of other communications. And the legislative branch is very much out in the open. All right, third, I have to say something about education. I think this is an area where you have really tied our hands. I think this is a hash of various authorities. So Article 10, Section 1, it is the goal of the people to establish a system of education which will develop the full educational potential of each person. Section 5, the legislature shall provide a basic system of free quality public elementary and secondary schools. And then you take away our authority to do anything meaningful by adding Section 8, the supervision and control of schools in each school district shall be vested in a board of trustees. And then the Board of Public Education, quote, is to exercise general supervision over the public schools. So if you're a legislator and you say, I'm looking at the data from the National Association, the NAEP data on educational progress, I'm looking at ACT test scores, I'm looking at any number of standardized metrics that are cutting across school districts across the country. When I was going to public school in Billings in the 70s, our measures on those scores consistently put the state of Montana in the top, typically the top 10, and usually the top 5. In the modern era, we're smack dab in the middle. So if you run the legislature and say, I really want to improve the quality of the education state of Montana, other than throwing money over the wall, which is also what we do with higher education, all we have is the power of the purse. We have virtually no ability to impact what's delivered and the priorities of districts. And I think there is a tie between the inability for the state to drive policy in education and the fact that our outcomes have gone well downhill in the course of my adult life. Finally, on rulemaking, there's obviously a tension. The administrative state is much larger than what the delegates encountered in 1972. State agencies have rulemaking authority, which I would describe as gap-filling authority, but also sometimes it feels like it's far more than gap-filling. It's really, maybe it's not ultra vires, but it certainly is quasi-legislative. And sometimes I think there's an argument that what the agency has done is beyond what would have been intended by the legislature. So we have tried to build mechanisms in to ensure that we review rules and we have the capacity to reverse rules to the extent that we don't believe they're consistent with the grant that we had. And given how numerous rulemakings are and the scope of what is at issue, we do try to pay attention to that to ensure that what it is that we were trying to do legislatively isn't undercut by a separate rulemaking. And obviously, we have to monitor that fairly carefully, but it is really in this era, 50 years after the enactment of the Constitution, there's a lot of legislative activity that happens within the executive branch rulemaking, and it's really up to us to preserve our authority, which we are attempting to do through some of the things we've done legislatively in recent sessions. With that, I'll close. Thank you.
We're going to try to reserve some time towards the end of our panel for some interaction between the panel members, and I'm sure that the executive will love to respond to some of Representative Mercer's comments. Here today, filling in for Lieutenant Governor Juris, who is in Red Lodge to meet with FEMA officials today, we have Governor Gianforte's Chief Legal Counsel, Anita Milanovich. And the Constitution sprinkles specific authority for the governor throughout the Constitution. But Article 6, Section 1 provides that the main function of the executive branch is to see that the laws are faithfully executed. Now that takes me back to Humpty Dumpty and whether words can have so many meanings, because in my experience, I wish that the framers had chosen the words that the laws were faithfully administered, because some administrations seem to take execution of laws in an entirely criminal context. So, to give the executive view of their authority and to maybe respond to Representative Mercer with regard to rules and to lead us into some further discussions, we have Ms. Milanovich.
Well, thank you so much for this opportunity to participate in this panel. I can't pretend to take the place of Lieutenant Governor, who was intending to speak and certainly is exceptionally qualified to do so. At the same time, as a former constitutional litigator, it is my privilege to speak on this important topic as it relates to the executive branch. To that end, I'll focus my remarks on the exclusive powers given to the executive branch and how that interplays with the other co-equal branches of government. The preliminary question, of course, is who or what is the executive branch? Article 6, as was alluded to, gives us direction. Section 1 creates executive offices, 6 of them in total: the governor, lieutenant governor, secretary of state, attorney general, superintendent of public instruction, the auditor. Section 7 creates executive agencies, or at least authorizes the creation of executive agencies, up to 20 departments to which boards, bureaus, commissions can be attached. The governor, described in statute as the chief executive officer of the state, oversees the executive branch. As to the agency, he supervises and directs them. As to the executive officers, he supervises their official conduct. The question then is, what is the power or role of the executive branch? And that is, I believe undisputedly, to effectuate and implement the law. Again, Section 4, alluded to by our moderator here, directs that the governor shall see that the laws are faithfully executed. For agencies, that looks like enforcement and, where needed, rule adoption as authorized by the legislature. It is here in the executive's exercise of this implementing power that we see the interplay, the checks and balances between the legislature and the executive. Statutorily, the governor can veto a bill. Vetoes can be for any reason. Perhaps the legislation seems imprudent, unnecessary, unconstitutional. This veto, of course, is not an absolute right. As Representative Mercer alluded to, they can be overridden. Regulatorily, the legislature requires that all rules cite to the statutory authority for the rule and tasks committees with review of all proposed rules within their respective jurisdiction. These committees can object to a rule, they can recommend amendments, and ultimately, whatever the course chosen by an agency, the legislature by bill or joint resolution, depending on the status of the legislature, whether it's in session or not, can direct the adoption, amendment, or repeal of any rule. The legislature can also modify the governor's authority where it is established in statute. We saw this last legislative session in relation to the emergency powers given to the governor, where the legislature, in response to the prior administration's exercise of emergency powers in 2020, required legislative approval for most emergencies insofar as they would to extend beyond 45 days. I think the more interesting question then is what threatens the balance of this relationship, what creates the risk of encroachment on legislative power on the one hand and this implementing power on the other. Perhaps most obviously, an agency can exceed its authority and can attempt to be legislative. But perhaps less obviously, but equally important, the legislature can unduly micromanage agency rulemaking, the effect of which is to hamper the agency's implementing power and does not, and when it comes to a committee reviewing a rule, does not represent the will of the people in that micromanagement. An example of this we saw with legislation last session, and forgive me, Representative Mercer, as it was his bill. We saw the legislature putting parameters on when rules could be adopted, putting a 90-day moratorium on rules the months preceding a legislative session. The effect of that has been to draw to a standstill agencies' ability to implement the statutes they are tasked with implementing in a very onerous way. Another way in which this balance can be threatened is when statutes are not well written. This leaves agencies to make the best effort at figuring out legislative intent or perhaps more nefariously, I suppose, are left to their own devices, subject to our friends in the judiciary who will address the issue through litigation and legal challenge. Conversely, there are times when statutes are clear, but do not apparently reflect legislative intent. Agencies must enforce statutes as written, as required by the legislature's own statutory interpretation rules. Nevertheless, agencies may be tempted to correct legislative error, and this is inappropriate. This may be where the judicial check can come into play. In addition to the executive and legislature serving as checks on each other, the judiciary, as the final independent, impartial arbiter of the law, can help the executive and the legislature preserve their balance. And I will leave it with that.
Thank you, Ms. Milanovich. The third branch of government, the judicial branch, in some ways is more restricted than the other two branches of government in that the judicial branch can only take up issues that are brought before them by parties challenging either the legislation itself or the implementation of the legislation. And Justice Jim Rice is here today to represent the judicial branch, and he has graciously agreed to discuss what I think was a textbook case of separation of powers and the various roles of the branches, because this issue has been finally resolved and decided, at least for the case in point. And Justice Rice is going to discuss the role of the judicial branch and also address the dynamic tensions between the branches that played out last session over legislation to change the way that justices are appointed to judicial vacancies. Justice Jim Rice.
Thank you, Greg. Good morning, everyone, and panelists. It's a singular honor to be here and to be a part of your sessions this week in commemoration of the Montana Constitution. And I am deeply humbled by the invitation to address you today. Yesterday morning's session was just fabulous and impactful, hearing from the delegates and the members of their family about their experiences here at the convention and the pride that they took and still exhibit in their lives today about their role. One of the delegates who did not have a representative here yesterday to speak about their involvement, a person who is responsible for much of my knowledge of American and Montana history, was Dr. Richard Rader from Bozeman. And he was a college professor of mine and a wonderful teacher and professor and a wise person. Our relationship developed into one of friendship. In fact, he and I served together on the Presidential Search Committee at Montana State University. He is a faculty representative and me as a student representative that invited President William Teets to become the president of Montana State University. Wonderful experience in that presidential search, and I think a successful find. But Dr. Rader also was an author of one of the seminal texts on Montana history, Montana, A History of Two Centuries, written in the 70s, but still being cited in news reports today as authoritative, and it's my Bible with regard to Montana history, at least up to 1976 when it was published. Interesting, Dr. Rader was not fearful of controversy, and he wrote the book with Dr. Michael Malone, a fellow college professor at Montana State University who went on to be president of Montana State University. And in a time when Mike Mansfield was in the U.S. Senate, Lee Metcalf represented Montana in the U.S. Senate, Tom Judge was governor, and no Republican could win a statewide election in Montana in the 1970s. they predicted a strong resurgence of the Republican Party would occur in Montana. And I remember Dr. Rader discussing with me the flack he took from his Democratic colleagues about that prediction. And 10 years later, Stan Stevens was governor, Conrad Burns was in the United States Senate, and the Honorable Mark Roscoe was Attorney General. So I guess the proof was in the pudding, and that's what makes this a real good book. So. Speaking of controversy, as I looked over my comments that I prepared today on the topic of the rule of law and the separation of powers and checks and balances on the branches, I thought, you know, I think maybe my comments require a warning label, like parental discretion advised. The content of this presentation may be deemed to be controversial. I'm not a person who seeks out controversy, but sometimes controversy finds you where you are. And really, I'm not doing anything more than just reporting on controversial events that have occurred in the controversial time in which we live. Because indeed it does affect the rule of law and the separation of powers. We live in a time of extremism. We've heard a lot about the extreme polarization in society about our viewpoints, and that has given legs to extremism in our words and language, and extremism in actions. This is beyond the right of protest, even robust protest. It's beyond the exercise of free speech, and it's beyond the right to petition for redress of grievances. These are extreme actions that undermine our institutions and tear at the fabric of the rule of law. For the first time in our nation's history, the transfer of power after a national election was not peaceful. The peaceful transition of power is a hallmark of the American system, or at least it was. Responses to police excesses have not been petition for redress and have not been protest, but have been violence. The destruction of private and personal property. The taking over of the police station. A famous former NFL quarterback, displeased by a jury verdict after a trial, said, "This proves our system should be abolished." Abolished? That's the language of our dialogue today. Not changed, not reformed, not bettered, abolished. The nature of our language. Maybe you saw last weekend the Washington Post editorial that said, "There's another January 6th coming." It's about the attempts there will be to rush and take over the Supreme Court building, to disrupt its proceedings, to assault and intimidate justices in their private homes. Yesterday, NBC published an article entitled, "Concerns Grow Over Rising Political Violence Across the United States." I wish I could say that that was just happening in faraway places. No, it's reached the shores of Montana. And we have seen it here. Now, my next comments are not meant to be a political statement, or is not meant to point a finger of blame. I hope we can learn from what has happened in our state and be better for it. In response to the perception that judges were communicating with each other inappropriately about legislation pending before the legislature. Last year, the legislature issued subpoenas to seize, without notice, massive amounts of judicial communications, judicial emails, on a tight trigger time frame, less than 2 days. In response, the Supreme Court issued an order temporarily staying the subpoena until responses from the affected parties could be received, and the process that you heard about yesterday, privacy review, confidentiality, privileged information, could be checked in those emails before they would be disclosed. And in response to that order, the legislature and the Department of Justice notified the court that they refused to abide by the court's orders and would proceed as they deem fit. That was not Bill Mercer. And the extreme language that we've seen in our nation went along with it, where a statewide public official said to the public, the Supreme Court justices on the Montana Supreme Court are corrupt. Corrupt? I don't feel corrupt. And then the legislature issued subpoenas for the judicial communications and the personal communications of the justices, including what I do on this with my family. I was sitting in my living room one night, I'm thinking about all this, and I'm thinking about what's happening in the nation, and I thought how foolish I have been and how short-sighted to assume that our institutions would always endure. Didn't you just think they would keep going on forever? I did, and the thought flashed into my mind, the Gettysburg Address, Abraham Lincoln asking whether this nation is conceived and dedicated would long endure. These are questions we have to ask and answer today, and each generation has to ask and answer. I see that my time is up. I do play by the rules.
No. Continue, please.
I've gotten an extension. And as I sat there thinking about that, will our institutions be lost? And this brilliant thought hit me. And I knew it was brilliant by the force and clarity with which it hit me. And the thought was this: over my dead body, and I'll quickly wrap this up so we can entertain your questions. But I wrote an opinion in the case that this subpoena issue had grown out of, starting back at the Federalist Papers, coming forward to the Montana Constitution. where it is unquestionably and irrefutably the province of the judiciary on all matters that are brought to it to declare what the law is, even to the legality of the actions taken by the other two branches of government. And then I did something else, and it was really hard because I love this institution of the legislature, and I served in it right down here, several rows ahead of Dorothy Bradley. And I have great respect for legislators and the work that they do. I served in the centennial session of the legislature celebrating our state's 100th birthday. The president came, stood right here. I sat there, he stood right here. Celebrating our system, our institutions. So it was hard to sue the legislature. But I did, because that's what I believe the rule of law requires of me. I'm not the Supreme Court, I'm just a person. And if you subpoena my judicial and my personal communications, I'm not going to like it. So I took it before a neutral magistrate downtown in a court of law, and we duked it out. And as of today, the legislature is permanently enjoined from having my judicial and private communications. Thank you.
Okay, we have approximately 15 minutes left on our allotted time slot, and I don't know how anyone's going to possibly follow that. But I would like to open up to the panel responses to anything that any of the other panel members have said first, and we're just going to do this seated so that we'll save a little bit of time, and then if time allows, we will open it up to questions from the audience. So does anyone have any questions for any of the other panel members first, or responses to something that was said?
Yeah, let me lead off. So I want to respond to both panelists. I'll be brief with respect to the discussion that Anita made on rulemaking. The context of the bill is to say the legislature is at its weakest when interim committees have finished their business at the end of the year preceding the legislature. They have ceased to meet, so there's no ability for them to invoke the rule review authority that we have in statute. So the purpose of the bill was to say you cannot promulgate a rule in the last quarter of a calendar year preceding the legislature, because if you can, then that potentially evades our ability to review it. And so it may be a work in progress, but the principle was, how does the legislature preserve its authority on rule review if an agency can do something after we have left, which happened at the end of 2020, which is the inspiration for the bill. With respect to Justice Rice's comments, I don't want to relitigate the case. I will say this. The interesting public policy question is, where does the right to know begin and end with respect to all the branches? There's a very interesting opinion from the court in 1999 at the time of the appointment of the 5th commissioner on the Reapportionment Commission. And the order itself is very brief because it simply says the court has appointed this particular person to be the 5th member on the commission, the other 4 members having failed to find a 5th person they could agree upon. But in the balance, there's a dissent from Justice Nelson that questions, well, should we have closed this proceeding? And he took the position no. And eventually the legislature passed a statute to say the judiciary may close proceedings in adjudicative matters. So I think one of the questions that really remains unresolved is how far does the right to know go with respect to emails and other deliberations? And I don't think we know that. Now, I understand Justice Rice is saying, yeah, but that's not what happened here. We didn't have a right to know request, and I'll stipulate to that. But I think the larger question for the future is, does the right to know extend to the judicial branch, and to what extent? And I think that'll be an issue that we'll continue to wrestle with. So let me stop there.
If I may just briefly respond to Representative Mercer, I guess I would observe with the rule that committee oversight doesn't preclude the adoption of a rule anyway. And in the event that an agency were to adopt a rule within that window of time, the legislature is eminently convening and can certainly respond promptly to any issue that might linger there.
Okay. I'll just throw in my 2 cents on this administrative rule issue also, that this has been a perpetual source of tension between the legislative and executive branches of government. And I think that part of it comes from the fact that the legislature meets so infrequently and for limited durations of time, which means that the legislature, out of necessity, has to delegate broad authority to the executive to carry out the laws that the legislature has passed. There used to be a sign that hung over the bar at the old Bert and Ernie's in downtown Helena that said, "Welcome to Helena, where the biennial legislature meets semi-annually." And I think that I have never been an advocate for special sessions. I think they're basically a nightmare for everyone. But when the legislature met more frequently, I think that there was more pressure put on the executive to be responsive, because once the legislature was in special session, they could address anything that a majority of them chose to address by calling themselves into a special session. So that threat, which used to exist, no longer does, because special sessions have nearly disappeared.
And I just want to add to that was another great thing that the delegates did, was actually give the legislature the ability to call itself into special session, because we didn't have that ability under the '89 Constitution, and that at least created the potential that we would do that and be able to conduct business even if the governor did not want to call us in.
So anybody on the panel have anything else they want to add? Okay, we have 10 minutes. I'd like to open this up to any questions members of the audience may have for any of our panel members. Senator Tao.
Well, I wanted to comment about what Mr. Petesch just said is, I think, very true. There are not very many of us, but a few, like myself, who have actually, out of how many years has Montana been a state? 150 some years? I have attended half of all the special sessions called. And I think that's kind of an interesting comment. But I wanted to question to, well, any of the panel members, Justice Rice in particular probably, Marbury versus Madison is probably the worldwide acceptance of the notion that the judiciary has the authority to declare a law unconstitutional. And that's pretty important. But it came about simply because because the Chief Justice of the Supreme Court realized that he didn't have the authority, he didn't have an army to enforce his decision, and if he had ruled in favor of Marbury, there would be no way it would be enforced. President Jefferson simply would not do it. Now, with 150 years of background and acceptance almost worldwide of that notion, that does show that the judiciary does have some authority, but it still lacks an army to enforce it when it comes right down to it. So what are we going to do to make sure that the judiciary maintains its authority?
I'm getting looked at, so I think I'll try that. Marbury versus Madison was the first Supreme Court case that discussed the judiciary's authority to declare the acts of Congress unconstitutional. However, it existed in our constitutional history even long before Marbury, and the power of judicial review was not created by the United States Supreme Court. It was designed into the Constitution as discussed in the Federalist Papers, and citizens were advised before they voted on the U.S. Constitution, or the states rather, that this would be a power inherent in the judicial branch. So Marbury wasn't the origination of that principle. It was actually earlier and part of the compact that the people entered into when they approved the U.S. Constitution. Marbury is the first case where it was actually applied, but you're right. And the same is true now as in 1803. We have no army. We don't even have a bailiff. I mean, at least the U.S. Supreme Court has marshals. We get a law clerk too. Our power to enforce our duty comes from the support of the Montana people. That's where we get it. And that's why it's so important for us as a court to abide by the parameters of our duty, because it's easy for justices just to start writing on a piece of paper and do all kinds of things that are beyond their constitutional duty to do. Oh, I think I'll just kind of legislate a fix here. Oh, this issue isn't raised in this case? That's okay. I'll fix that too. It's very easy to write words on a paper. And that's why we are diligent in our duty. We ask the question not, is it possible to strike down this legislation? No, that's not the question. The question we ask, is it possible to affirm it? Can we affirm it? Is there a way to respect the legislative process? I think I've gone into preaching here. Hopefully that comes close to answering the question.
You may have a second calling, Justice Rice. Does anyone else have a question for the panel? Yes.
No. Clarification, it sounds like we're debating more of a republic versus a monarch in this situation. And as one of our leaders said, if we can hang on to it.
Anyone else? Yes.
During this last legislative session, it was an unprecedented attempt to challenge the other branches of government. And so my question is to Representative Mercer. Could you tell us just how much instruction or clarification that new legislators in particular, since we're facing term limits, are familiar with the Montana Constitution and the separation of powers. Could you address that perhaps? How much are they given information about our Constitution? Thanks.
Yeah, thanks for the question. We have an orientation at the beginning of every session that is staff-led, and there actually is a session called Law School for Legislators. And I think because of COVID, some of that was truncated, and I'm not really even sure whether we did Law School for Legislators last year. So I think the way I'd answer the question is there's structured training, and there's a lot of printed material made available, and then I would say it's going to be variable depending upon the individual member. But there is an attempt to do an orientation, but as I said, with 35 new folks, there's a significant steep learning curve, and that extends to a variety of things, including the Constitution, but certainly the budget and many other things. But their staff does everything that it believes it can do at the outset to try to provide the basic tools, and then with the hope that that capacity continues to grow for all of us. I always say this is a very humbling experience. I mean, I went to law school. I've practiced for 30 years. I interned here in 1985. My father was a legislator. I have a master's degree in public administration. There are all kinds of things that I have had to learn even with that background. So it's just a feature of our system.
It's hot, Mel.
Legislators have been notoriously ignorant of the different powers of the branches, and I want to give Carla Gray, former Chief Justice, credit. It was she that insisted that there be an orientation for the legislature on what the judiciary does. And she's the one that single-handedly came to one of the rooms downstairs to inform everyone, and she's the one that started this. It ought to continue. Representative Mercer, I wish you would spearhead that and get it going, because it's quite important. And when the meaning of this particular debate sinks in, it has big implications for this state. Thank you.
We're just about out of time, so I want to give each of our panelists a last word, and we'll go in the order we started. Representative Mercer.
Thank you, Mr. Petesch. I want to close with what Delegate Garlington said on the floor. I take it on the last day. I saw this written up. Quote, "Ahead I see not only the imminent task of ratification, but beyond that, the more important task of leading our fellow Montanans into the reality of better government for a better society. That remains the task, and I believe the jury will always be out on that for sure." Thank you.
Anita.
Thank you. I think the rule of law, which is where we started with this conversation, is fundamental. And I think it is an amazing construct how our government has been formed to have checks and balances among each other. And notwithstanding where the executive and the legislature may tussle, I think that tussle is expected and it's designed. And so I agree with Justice Rice. Perhaps the rule of law is under threat. I, for one, over my dead body as well.
Those things may be arranged yet. I don't know, man. Just to close again, to thank you for being here and thank you for this opportunity. You know, when I taught at Law School for Legislators, which I've done for many, many sessions, I enjoy explaining to them that, you know, we talk about checks and balances, and that's a little kind of scary. I talk about give and take. I say, you know, you guys you overrule more of our decisions than we overrule of yours. There's lots of legislative options in response to a decision by the Montana Supreme Court. In the case, you can ask for a rehearing. You can pass legislation if we've interpreted something wrong. You can amend the Constitution. You can elect different Supreme Court justices. You can do a lot of things. You can't refuse to abide by court orders, okay? So thank you. And I hope that the courage and the determination and the grit that the delegates showed in passing the Constitution will be passed to a new generation who will be sure to keep it. Thank you.
I want to thank our panel today for a terrific discussion, and since I'm the moderator, I'm going to take the last word because I've never been able to before. Representative Mercer alluded to Francis Bardino, who probably was one of the longer-serving legislators here and maybe had more individual authority because of his knowledge and his personality than any other legislator. And Representative Bardino once told me a story about going home after a legislative session, and he was very pleased with himself that he had gotten a lot accomplished. And he had stopped at the gas station in Harlem and was filling up his truck before heading out to his ranch. And he said one of his neighbors pulled up at the pump next to him and got out of his truck and said, "Francis, where have you been all winter? I haven't seen you. Have you been sick?" And I think that's just a reminder that no matter how we all view ourselves when we're serving and the authority that comes with that and tremendous responsibility, the final authority lies with the citizenry of this state, and I hope that they will be watchful of the way that their elected officials handle that responsibility, and they are the ultimate check and balance of power. Thank you for your time.